Welcome, everybody. We're excited to have a really excellent panel for you today to talk about the SAVE program, which is the new loan repayment program that's proposed by the Biden administration. And many people are calling it loan forgiveness in a different form. So we have been extremely fortunate over the past year or so to be following all of the ins and outs of what the Biden administration is doing with regard to loan forgiveness. And you all likely remember that we had a loan forgiveness policy that was struck down by the Supreme Court in Biden versus Nebraska. And in that ruling, the Supreme Court not only rejected the president's policy itself, but also declared that the powers to enact, quote, a mass debt cancellation program are ones that Congress would likely have intended for itself. And despite that, I thought, very clear admonishment, just hours later, President Biden was at the Oval Office, was declaring that the court tried to stop him but could not, and was directing his Department of Education to find another way to forgive loans. But that's not all. They've been forgiving loans throughout the president's term through a lot of smaller but still extremely consequential programs that have amounted to tens, if not hundreds of billions of dollars in loan forgiveness. And perhaps most consequential of all, have created a new way to repay loans called Saving on a Valuable Education, or SAVE. This program is loan repayment explicitly, but implicitly it's a way to forgive a large amount of the loan portfolio, not just now, but on an ongoing basis. It's estimated to cost up to $559 billion over 10 years, and that number may even grow higher given some of the incentives of the program, which we'll talk about. The SAVE program now, like the original forgiveness in Biden versus Nebraska, is being challenged. There were 11 states that initially sued the Biden administration, and now 7 more states have joined them. That's why we're extremely fortunate to have some of the people who are in the thick of it challenging this program, and I'm going to introduce you to each of them right now. First is Paul Zimmerman. Paul is the senior counsel at DFI, which has been challenging the Biden administration on all sorts of different policies. From 2019 to 2021, he was counsel at the U.S. Department of Commerce and has worked in multiple roles for the Federal Society and in other capacities. So we're very fortunate to have Paul to talk with us about some of the implications for this program and why it's different from all of the loan repayment programs that have come before it. Stephen Petrani is joining us from the state of Georgia. They're actively involved in one of the suits against the Department of Education. And before joining the Office of Attorney General, he was an attorney at Jones Day in Washington, D.C., and served as the law clerk to Justice Samuel Alito on the Supreme Court. Sheng Li is litigation counsel for the New Civil Liberties Alliance. He also was at the Department of Labor, where he worked as counselor to the administrator of wage and hour, and led numerous efforts to remove or simplify burdensome regulations. He's a graduate of Johns Hopkins and Yale Law School, and was managing editor of the Yale Journal of International Law. And finally, Abhi Kemble is joining us. He's the Deputy Attorney General in the Kansas Attorney General's office. Prior to that, he was Assistant U.S. Attorney and was prosecuting crimes in the Southern District of Indiana. He is also actively involved in some of these cases, going to tell us about his work. So we have representation from both of these challenges to the Biden administration. We have people who are looking at this from all angles. There are so many challenges with this. A couple probably seem obvious. There are many people who are talking about just the sheer cost, the fact that Congress has not appropriated these funds. These are funds that are just going to are expected by the Treasury, are not going to go to the Treasury, and have already been spent on other things. And there's just kind of the fourth grade government problem to this, right? Everybody learns that it should be Congress that is appropriating, that it's the executive branch that carries out the laws. At best, Congress gave the Department of Education a completely blank check that I don't think they ever anticipated the department would fill out with so many zeros. But at worst, the department has completely made up a new authority in order to forgive hundreds of billions of dollars worth of loans before anybody can stop them. But in addition to that, there are a lot of other problems that will affect many of the problems already evident in higher education. You have cost, of course, but this will probably only make some of those challenges worse. If there is ever less accountability on repayment, it stands to reason that cost of attendance will only go higher. If there are incentives for students to borrow as much as possible, then institutions which do have some discretion and do have some ways that they can game the system a bit to raise the cost of attendance, usually they're not doing those things right now because it would harm students. But if students can borrow at or near the maximum and then expect that much of those loans will be forgiven, there is much less reason for the individual colleges and universities to advise students to be careful and to set reasonable limits on the growth of tuition and fees and living expenses and other costs. So we can expect that to only rise. And many of the institutions that are part of the student loan program or are part of the Title IV program today are not part of the student loan program. Community colleges, many of them only offer Pell and grant aid. They don't offer loans. That may change because of this. If there is such a great incentive to borrow and not repay it, many of these community colleges may start to offer loans. And when they offer loans, they're not just offering loans for tuition, which in many community colleges today is reasonable, but also for living expenses. And you might imagine community colleges located in expensive places could have students that rack up very significant loan balances with no expectation that they will ever repay them. And so you can start to play this out, and it bodes very poorly for students, for taxpayers, and frankly, for the future of the student loan program. So with that intro of a whole lot of doom and gloom, we're going to find out what each of these esteemed panelists is doing to challenge some of these policies and hopefully help us restore the loan program and the overall higher education system to a bit of sanity and a bit of normalcy. So I'm going to start with Paul. And Paul, tell us a little bit about the SAVE program in the context of some of the other programs that have come before it. The defenders of SAVE will say, look, this is just the natural extension of what the Obama administration did in creating new repayment programs. There are new repayment programs going back to the 90s using new authority. Tell us why this is so fundamentally different that there need to be legal challenges that you hope will be successful.
Well, first, thanks so much to you, Michael, and to AEI for putting on this conversation. We at the Defense of Freedom Institute have been following these issues closely for years and are working to push back, especially in a regulatory manner, filing comments, advising the public on these issues. So it's really important that this is taking place and that people are getting educated on the SAVE repayment plans. I love to start with the text of the statute at issue that authorized this plan. It was passed in 1993 by Congress in its overhaul of the federal student loan program, creating the direct loan program. Small part of that statute with right now huge ramifications from the Biden administration. And all it says is that the secretary is to offer student loan borrowers in the direct loan program an income contingent repayment plan with varying annual repayment amounts based on the income of the borrower, paid over an extended period of time prescribed by the secretary, not to exceed 25 years. So over the past 30 years, and even at the time that it was enacted, Congress never envisioned that plan to have as its central feature forgiveness and loan cancellation, as opposed to repayment, which is the term that is actually used in the statute. Another term that's used in the statute is over an extended period of time. Extended, I think, means more than the standard repayment plan, which is set at 10 years, which I think the SAVE repayment plan, as I'll get to in just a minute, will totally disregards. That authority of the secretary is limited. So Congress never intended for the secretary to provide for repayment periods of even under 20 years. They never intended massive amounts of loans to be forgiven under the plan. At most, they believed that at the end of an extended period of time of 20 to 25 years, a little loan might be forgiven, but that the bulk of all student loans repaid under the plans under this plan would be paid. We have some great research coming out of DFI, authored by Jason Delisle, who is a federal student loan program expert, who really looked into both the Congress's interpretation of the income contingent repayment plan provision and the Clinton administration's interpretation of it in the ensuing years and their implementation of it, showing that no one expected that repayment periods would be so short and that so much loan forgiveness would occur. And just to bring up one example prior to the Biden administration SAVE repayment plan, the previous most generous plan offered under the Obama administration, it was projected even by the Biden Education Department that people repaying under that plan would pay more than they took out on average. And that is totally flipped under the SAVE repayment plan. So here's how the SAVE repayment plan makes that work. So under other plans, the department excludes an amount of income from the amount that's used to calculate each monthly payment, which is called the discretionary income. So it excludes an amount of income from that discretionary income that is 150%. The SAVE repayment plan now raises that to 225% of your discretionary income, which I believe is around $33,000 per year for people, including for just people starting out. Anyone below that number does not have to pay a cent of monthly payments toward the department on the income contingent repayment plan that's being created by the Biden administration. Out of the discretionary income, the SAVE repayment plan only requires a payment of 5% of that income, which has been halved from the 10% of income that's used on previous plans. And then kind of the kicker in the SAVE repayment plan is that it forgives all of the debt of anyone who's borrowed $12,000 or less in student loans at 10 years for those who have borrowed under that amount. For each additional $1,000 that the borrower has borrowed, it forgives the debt 1 year later. But that's a complete loan forgiveness at 10 years for people who have borrowed $12,000 or less. And finally, it cancels any interest charge beyond what is covered in the borrower's monthly payment. The borrowers are for every $10,000 of debt that they've taken out that is under the SAVE plan are only expected to cover on average $7,000 of that $10,000. And then undergraduate borrowers are only expected to to pay $6,000 of that $10,000. The rest is covered by taxpayers. That was never anticipated by the Congress who enacted the program, who expected it to not have significant cost or even to be budget neutral. So this is really a difference in kind that I think is making this plan susceptible to the legal challenges that we're seeing across the country, and that we're going to talk about for the rest of the conversation. I'll stop there, and I'll save the rest for Q&A and for the discussion.
Yeah, great overview. And just to kind of recap that, nothing below 225% of the federal poverty level, 5% above that. That's significantly more generous than what it was before, which was 10% above 150%. But as you did a really nice job of pointing out, that's not all. There are many other things that they're doing to tinker to make this especially generous for students, but not so generous for taxpayers who are now being asked to pay for an entitlement program, essentially, when it was always designed as a loan program. I should also mention I spoke with Joe Flater, and Joe was a staffer for Representative Tom Petri when that provision you were talking about was written. And I asked him, was this discussed? What was the goal here? What was the intent? He said it was definitely the intent that most people would pay off their loans, and it was not the intent to turn this into some sort of massive subsidy. And so he was there, he was clear, and he actually got some of this into the congressional record. So it's not just his word, it was actually printed in the congressional record that this was meant to be a loan program, just with a little bit of a more creative repayment structure that might look a little bit more like an income share agreement rather than just a standard loan. So great overview there, Paul. Stephen, you're involved in some of these cases and are seeing what's happening on the ground. You're helping to make the argument directly to the court. So could you just tell us a little bit about what you're doing, what the status is of some of the work that you've been doing, and what we should expect to happen next?
Yeah, so just to start, I do represent Georgia in court, but I'm not representing Georgia today. These are my views as limited by what I can say as an advocate for Georgia in ongoing litigation. But with the disclaimers out of the way, we and Missouri and North Dakota, Florida, a few other states filed a suit in the Eastern District of Missouri in federal court a little over a month ago now, and also filed for a preliminary injunction, which actually just got argued yesterday by my friend Josh, who's the Solicitor General of Missouri. And so basically, for those who followed last year's loan cancellation litigation, it was in fact a coalition that included Nebraska. Obviously, it was versus Nebraska was a part of the caption, but Missouri was also part of it, and that ended up being very important because there are really two big issues here. One is the merits, which is, does the Biden administration or any presidential administration have the legal authority to do what they're trying to do? But one big question, and this was a big question last time around as well, is whether the states or anyone has standing to sue, to challenge these programs. And as anyone who follows these sorts of things could probably tell you, and certainly anyone who litigates them, the hardest kind of presidential action to push back against in terms of litigation is one where the president just gives people money, right? There is no such thing as taxpayer standing. You can't just argue, well, you're spending the billions of the American people's money without justification. But the Supreme Court held last time around that an instrumentality of Missouri, MOHELA, the Missouri Higher Education Loan Association, did have standing to challenge. And this time around, we also have some other good theories as to why really all the states have standing to challenge these really difficult to defend on the merits actions. I'll just mention a couple of them. I mean, one is, it's a little complicated as to why, but there is a different program that allows for some loan cancellations when you work in a public interest firm or state or the federal government. And one of our arguments for standing is because of these changes, that program is essentially pointless now, because everyone essentially gets their loans paid off to a much greater extent. And so it harms states that rely on programs like that in recruiting for legal positions, staffing positions, so on and so forth. So that's one theory we've got. Another theory is that it harms our tax revenues because Georgia, at least, and a lot of states do this, they peg their own revenues to how the federal government identifies adjusted gross income. And for the next couple of years, these cancellations are not going to count as adjusted gross income. So that means that they won't for the states either, which is going to be a revenue hit to us. And then, of course, there's the primary, that's sort of the theory that won last time, and the Supreme Court didn't need to go on to any other theories, which is that MOHELA, which is itself a loan servicer, is going to be losing money because there will not be loans to service as they get canceled. So the status of our lawsuit right now is, as I said, the preliminary injunction motion got argued yesterday. We're cautiously optimistic. The judge seemed to be a little seemed to be very skeptical of the administration's merits arguments, especially this argument that, as Paul pointed out, the phrasing of the statute is, I might get the word slightly wrong, but it's more or less that this payment plan is supposed to not go past 25 years. And DOJ is basically using that to say, well, that means that after 25, you can just cancel it, which is kind of the exact opposite, obviously, of what that means to any ordinary reader of the English language. And the judge seemed to sort of get that. I think on standing, the judge seemed to get that at the very least MOHELA has standing, and that should be enough. Our hope is that we get an order relatively quickly. This suite of rules officially goes into action on July 1st. Now they've kind of already started doing a lot of it, so I don't know how much that July 1st date matters anymore, but at least as a technical matter, that is when the rule is supposed to go into effect. So we're hoping to get an order before then. Obviously, we're hoping for a good one. If not, we'll go to the 8th Circuit and we'll ask the 8th Circuit to, on an emergency basis, stay this. Not going to belabor the point, but for all the reasons that Michael laid out and Paul as well. I mean, this is very important. And once the money goes out the door, you can't get it back. So we're hoping that we can get relief pretty quickly.
And you're involved in your case with Missouri, so that'll be interesting to watch. But there are other arguments here. But it's interesting. You talk to people about this issue, and even the really progressive people you talk to, they kind of say, "Yeah, it doesn't sound super legal. It doesn't really seem kosher for the administration to spend hundreds of billions of dollars just because they feel like it, and just forgive all sorts of loans that everybody knew at the beginning were supposed to be paid back." Those people will say, I hope they get away with it. But there are, I think there's pretty wide bipartisan agreement that this, on the merits, is not really something that the Department of Education should be doing. But there's this standing question, I think, just as you laid out, Stephen. There's this issue of how do you actually reach the merits in the case? And Sheng, I want to bring you in on that, because I know that issue of does this make the other loan repayment programs competitively worse off? I think about veterans in particular, and I know these standing arguments are not really reliant on veterans, but just to make people understand what a huge impact this policy could have. You talk to a lot of veterans, and part of the reason they go in to serve their country is because they know they'll be taken care of after, and they get really, really generous education benefits. Those benefits start to look comparatively not as good if you can just get them because, not for serving your country, but just because you feel like it. You also get not quite as generous, but pretty generous benefits through public service loan forgiveness. Yet another program that was originally intended to be a small, narrowly tailored benefit that this administration has blown the doors off of, but that's a story for another day. But the bottom line is public sector employers and nonprofit employers are using this as a recruiting mechanism. And Sheng, I know you've spent a lot of time on that issue and some of the other standing arguments. I'm wondering if you could just say a little bit more about the arguments that are being made and what your thought is on whether or not the courts will accept those.
Yeah, sure. Thanks, Michael. So I guess my opening's now limited to 3 topics. I'll start with the standing issue and some of the cases I've been litigating on standing. And I'm actually not litigating a case against the SAVE plan. I'm challenging other smaller aspects that are only tens of billions of dollars at stake. So because of that, I might be more free to talk about some of the nuances of the plan outside the litigation context. So and I'll end by just talking about how why kind of agency unilateral conduct on this topic might be the problem here. And on standing, it's if you think it's hard for states to get standing, it's even harder for private entities to get standing. That's the folks I'm trying to represent. And since the HEROES Act plan, NCLA has been representing the Cato Institute and the Mackinac Center, which is a free market group in Michigan, to challenge some of these plans, including the HEROES Act plan and some of the smaller loan forgiveness plans on this theory based on what Stephen just talked about, this public interest or public service loan forgiveness plan. I'll just go a little more detail on that. What it does is the government says if you graduate college and you come out with a lot of debt, you can work for a public interest organization. That could be a nonprofit, it could be a state government. And if you do that for 10 years while making your loans, you get your loans wiped away. So it creates a powerful incentive to work in a public interest capacity, as opposed to Wall Street or a big law firm or what have you. The problem is if the president comes around and starts just forgiving everyone's loans. So, right, before you get your loans forgiven if you work for the state of Georgia or if you work for Cato. But in the, if suddenly you get your loans forgiven no matter what, you have no incentive to work for the public interest anymore. And we think that hurts the public interest employer, whether that's a state or whether that's a nonprofit NGO like Cato. And then that should get us standing. We did lose a case in the Sixth Circuit recently on this issue. We're hoping the states, you guys will win and we can get a circuit split on this issue. But let's make that happen. I will mention, as Michael, you said, about veterans. We're not representing veterans groups, but the same incentive and the same logic applies. Right now, the military is struggling to meet its recruitment goals. And one of the ways it does that is to give student loan forgiveness to college graduates. And, at the margins, you're less likely to enter the military if you're getting your student loans forgiven because of a handout from the president. Now, so we it's really hard to get standing. We tried to actually sue the SAVE plan. We had a company lined up to do it, but they were actually afraid of regulatory retaliation. And we saw this actually last year when Mohila got the HEROES Act successfully challenged. DOE came back and slapped them with a several $million fine. So I think it's understandable that private companies might be resident to stick their neck out and challenge these things. But having done that, I think I can, we make clear, I'm a little more free to talk about the SAVE plan and maybe why it's so vulnerable in litigation. So Congress actually, at the same time as it enacted the PSLF statute, enacted something called the income-based repayment plan. And that's a congressional enacted statute that says you can get your loans forgiven if you make payments for sometimes it's 20, sometimes it's 25 years, depending on the exact plan. But if you make monthly payments and that are capped based on your income, and as Paul, you mentioned, it was 10% of your of 150% of the poverty line. Of income excess of 150% of the poverty line, you can get that cap, and that's a congressional. That's a congressional statutory threshold. And then the Biden administration comes in and says, well, actually, we can cap the payments a lot lower than that, and then forgive the loans even faster. That seems strange, and they cite a 1993 law. So if that 1993 law allowed Congress this entire time, allowed the Department of Education this entire time to authorize a very generous plan, why did Congress have to enact a separate law in 2007 to create a less generous plan? That seems quite illogical. In fact, if you go back and you look at the language of the 1993 Act, yes, kind of like the HEROES Act, if you squint hard enough and you look at the language, it does say, oh, it's a repayment plan, and it's, it has to be based on, it doesn't have to give any details other than it has to be based on income, and the repayment plan can't exceed 25 years. Well, under that logic, the department, for instance, could set a payment cap to, let's say, 1% of income over $1 million a year. and then the rest gets forgiven after 2 years, right? So it seems very improbable that the department, that Congress intended the department to have that sort of power. That's in fact what the Supreme Court held in the Biden v. Nebraska case last year. It was about the HEROES Act, but the logic, you just take that logic of you can't squeeze an elephant into a mouse hole, and you apply that to the 1993 plan, and I think you get to the same conclusion. And I want to end by saying, I'm not, necessarily against forgiveness of student loans. Some of these loans are quite predatory. There's a lot of people struggling. But when you have the president doing this on his own, you really remove the incentive for Congress to act here and to achieve some sort of compromise solution where they can target, folks who are really in trouble, who are really in need of this, and maybe actually, in exchange for that, add some kind of accountability measures for schools to make sure students who struggle are taken care of by the schools, or give the school some kind of incentive. But when you have the president and the executive branch doing this on its own, there's no incentive for either party really to compromise in Congress to actually, enact any kind of lasting solution.
Yeah, as I like to say, only the federal government could come up with a predatory loan on which it loses money. So congrats to them on that. And you also mentioned the Mohila issue where, yeah, they were part of the Missouri lawsuit last time and got fined on, for some wrongdoing the Department of Ed felt was appropriate. And they've also now had some of the loans that they were being paid to manage transferred over to the department. And there's some interesting timing on some of that, to say the least. So we'll stay tuned there. But this is a department that is aggressively trying to forgive as many loans as possible. Nat Malkus at AEI has been tracking a lot of the, very small programs. It's only several $1 billion that they're forgiving via press release. And it's something that I think has been a really understudied story in the midst of these really, really big programs that are hundreds of billions of dollars. Avi, I want to bring you in on this, and I know we've kept you waiting, but you're involved in one of these cases as well, and it's just fascinating that, and I think opportune timing that there are multiple cases happening. And I would love for you to share some of the things that you're working on and maybe some of the arguments that you're making that are slightly different than what we've talked about so far.
Yeah, sure. So our case is Kansas v. Biden, which is currently being litigated in the District of Kansas. So with our case right now, we just had an argument on the government's motion to dismiss, which happened this past Friday, which we think went pretty well. Assuming we get past that, we have an argument on the merits on June 11th. And a decision on that would be expected sometime before the rule goes into effect. So I just wanted to talk about a couple of this, build upon some of the standing as well as the merits that weren't covered by some of the other speakers. So on the public service loan forgiveness standing argument, the Mackinac case actually came right when the briefing was going on in our case. So a couple of the things that distinguished our case is, one, states can claim special solicitude, which private litigants can't when it comes to the public service loan forgiveness argument. And the way we built that in is that it is a quasi-sovereign interest that states are required to provide certain services to their constituents, such as law enforcement, education, and those types of things. And without a workforce that's able to do that, they're not going to be able to provide these services. And special solicitude can, in some instances, reduce some of the traditional injury and traceability arguments. So that is one of the layers that we added. And we also focused really heavily on which aspects of the program harm the state interest. In particular, it's the one that gives loan forgiveness at the 10-year mark, even if you didn't work in public sector for 10 years, as well as the fact that for anyone with a loan balance below $12,000, that creates a clear incentive to go into the private sector, especially if you're one of those people who is a year or two away from forgiveness and has another opportunity in the private sector. At that point, the incentives are to leave government service and do that. Another is the state instrumentalities piece. Mohila is not the only state instrumentality that's out there. We have 3 states in our coalition: Alaska, Texas, as well as one other state that has these instrumentalities that service FFEL loans. And one of the things that they've seen is a rush to consolidation as a result of the fact that FFEL loan programs don't get the same benefits that the SAFE plan has to offer. And in Alaska's entity in particular, they estimate that the loss to them is going to be 100,000 over the next 2 years. And a lot of that evidence was all given in the motion to dismiss hearing, and it seemed to go over pretty well with the judge. So we'll wait to see how that plays out. On the merits, two things that I wanted to touch on that the others didn't touch on as much. The major questions doctrine is very prevalent in this case, as it was in Biden v. Nebraska. In this case, the government, they didn't contest that this was a major question. And I think given the pure cost of the program, they almost have to concede it is, even if you go by their cost estimate of 150 billion, that's 3 times the cost of the Alabama Association of Realtors case, where they found 50 billion was enough to trigger an issue of major economic significance. And at that point, it's going to be, in our view, very tough to establish clear authorization to effectively use terms of payment for loan repayment to forgive loans altogether. And another was an arbitrary and capricious argument. This was not raised during Biden v. Nebraska, but one of the things that we found was that even though the final rule was published 10 days after the Supreme Court announced its decision to strike down the forgiveness in the HEROES Act, the cost estimates assume that the HEROES Act forgiveness would go through. So what that means is they assume that 430 billion would be wiped off the balance books when it wasn't. And they knew about that this entire time. Even during the proposed rule phase, the 8th Circuit had enjoined the HEROES Act forgiveness nationwide. So they basically did not take into account the actual cost of the program, which was 3 times higher than what some estimates say it was 3 times higher than what they said it was. And if they didn't really have a good answer for that, so if that's the case, then it could be struck down on the grounds that it's arbitrary and capricious, which was not an argument that was available in Biden v. Nebraska and was one of the ones that we made in this case.
Yeah, it's stunning that they just kind of, on a lot of this, said, that's good enough, publish it anyway. And some of those things, I'm wondering, Stephen, Avi, if you could talk about the sloppiness factor and if that's playing into this at all. But before you do, I just want to let everybody know that we're taking questions. And if you notice on the event page, there is a link to email Joe, and I'll give you his email address. You can send questions directly to him. It's joseph.pitts, Pitts, @aei.org. Or on Twitter, you can ask questions with the hashtag #ChallengingSave. And again, those links are available on the event page. So we hope you'll send your questions along. But before we go to some of the audience questions, just want to hear again, Avi and Stephen, is that sloppiness making your job maybe a little bit easier? And then by contrast, they're also trying to rush as many people as possible to enroll in this plan before a court can say anything about it. Does that make your job harder, or is that just about making it harder politically?
So yeah, there are, it definitely makes us have to move pretty quickly, because one of the issues is, even though the rule wasn't supposed to take effect till July 1st, they've given themselves the authority to effectively forgive loans early. And that's been a challenge to, keep up with the pace and at the same time have sound legal arguments that we're making to the court, but we have been able to do that. The arbitrary and capricious, I don't want to say it makes our job easier, but one of the things that we just noticed is, yeah, there was a lot of sloppiness in there. If you look at some of the responses to the comments, there was one commenter that specifically says, you should do another cost estimate because the Supreme Court is, and it was after oral arguments, likely to strike down the HEROES Act. And they responded by saying, we remain confident in our ability to forgive those and eagerly anticipate, or words to that effect, the court's decision on that issue, even though it was published 10 days after the court decision and they never went back to reverse that answer. Their response to that was a couple things. One, we're not required under the Higher Education Act to consider the cost of the program. which was an interesting argument. And then they tried to get a declaration saying that they sent it to the printer before Biden v. Nebraska came out, and that once it was there, there's nothing they could do about it, even though there was a 10-day gap between that decision and when they published it. And it's pretty routine, especially when a new administration comes in, to stop the printer and do that. But it never answered the question of the fact that it was enjoined the whole time from the proposed rule onwards. So they, absent some intervention from the Supreme Court to allow them to do it, that wasn't a rational, or that wasn't a reasonable cost estimate that they came up with. So I don't want to say it makes our job easier, but it gave us a theory that we didn't have in Biden v. Nebraska, and we were part of that coalition as well.
Yeah, I mean, I think really what it shows is a kind of a cynical attempt to avoid any kind of meaningful judicial review, because, as Avi pointed out, not only are they already doing this, but I mean, they have a plan C. There's another thing that they're trying to rush out right now as well. When this one, I think and hope, inevitably gets held to be invalid by various and hopefully many courts. And I think it goes to a point that, at least certainly as you go kind of up the chain of the appellate diagram, I don't know how much it matters to district judges necessarily, but I think it certainly matters more as you go to, circuit courts, and certainly the Supreme Court, is just the kind of brazenness with which the administration is sort of saying, yeah, we know we don't have this authority, but we're going to find something somewhere that we can at least call plausibly an authority to do this, and we're going to, cancel a bunch of loans before you can stop us. And during the pandemic arguments about vaccine mandates, Chief Justice Roberts asked a question about this, phrasing it in a way of like, he phrased it kind of more neutrally. Someone could say that it looks like you didn't so much think you had the authority to do this as you wanted to do it, and you just scoured the millions of pages of, the US Code, CFR, et cetera, to try to find some arguable basis. And I think that in this suit, much, following on the last year's suit, and then presumably the set of suits that are going to come with their next plan, it's essentially the administration admitting that's what they're doing. They know they don't have this authority. They don't care. Again, whether or not that's going to be all that persuasive on the merits to a given district court or move the matter along faster, I don't know. But I do think that has rhetorical power, at least as you kind of get to courts of appeals, the Supreme Court, that are looking at this in terms of, this isn't just about this case, even though this is a $500 billion incredibly important case, but also kind of the broader, like, you have lots of cases where you're trying to get us to say you have authority to do something. How much should we be believing that, as opposed to, well, you want to do this thing and you just went and tried to find something and you weren't even that careful when you did it?
Paul and Shang, you all are the legal experts, and I'm definitely not. So I have to ask you guys, I mean, again, this just doesn't even seem to pass the fourth grade US government lesson on, three branches of government and Congress being the appropriator. And I mean, what power does the Supreme Court have if, to Stephen's point, the administration is just going to make up an authority that they probably know they don't have and just kind of do it anyway? And maybe they do it 10 times and the courts can only stop them 3 or 4. That's a huge win for them to exercise power that constitutionally they don't have. Is there anything that the courts can do about this?
It is, and part of this is in part the court's view on the way statutes are interpreted has changed somewhat. And if you go back, you can actually see this problem beginning almost 10 years ago. We mentioned this. I mentioned this 2007 law, right? That capped certain payments, and that's congressionally enacted and congressionally authorized. And so what happened there was the President Obama in 2010 actually went to Congress and said, originally it was 15% of your excess income, discretionary income. And President Obama in his 2010 State of the Union went to Congress and said, hey, make this 10%, please. And Congress did. But Congress put a little rider on there and said, this only applies to new loans after 2014, right? So people who made loans before can't be helped by this. And what President Obama did was enacted a plan that uses the 10% threshold, but did it for everybody, including people who enacted loans before 2014. And he, as authority, cited the 1993 law. At the time, nobody thought to challenge that, right? Everyone said, well, he's really just basically extending this program, this 10% that Congress already authorized to a group of people that, to a new group of people. It should be fine. But I think this is kind of like the problem is like if you give a mouse a cookie, he'll want a glass of milk. Everyone thought that was okay. And then, all right, let's see what else we can do with this 1993 law. And you fast forward 10 years and you see the Biden administration expanding it, which I think this shows that you need to, when you see these violations, and even those, the initial violation might be a small amount of money at stake, as was the initial Obama plan relative to hundreds of billions anyway. You have to step in, and courts have to step in to stop it before it gets bigger. Because when it does get bigger, it'll be it'll be too slow to stop it.
I would just say quickly that this is just a pattern that's been going on in the Biden administration. I think the CDC eviction moratorium was a case in point where President Biden pointed out that legal constitutional scholars disagreed with him and that it would be struck down by the Supreme Court, but he would do it anyway just to appease his base. And I think that's the exact same thing that's happening here. I think that's happening in the mass loan cancellation redux, which is happening this year, Plan C, and it's happening in phases just before the election. I think that they know that they don't have the authority to do it, but they're going to say vote for the Biden, vote for President Biden, and we're going to push these plans through. And I would just say the Supreme Court can only settle cases or controversies under Article 3. What really needs to happen is a congressional fix of these statutes. They need to restrict, they need to fix any sloppy drafting, mistakes, broad authority, that the president is claiming under these statutes. And they need to specify exactly what's happening. And I think that fix needs to happen as soon as possible to prevent these kinds of claims, absurd claims of authority in terms of just claiming the authority to cancel every single student loan in the country. But they need to really cabin the president's authority and talk about the real limits on that.
And just in the spirit of bipartisanship, I would add this started at the Trump administration when Congress first, at the beginning of the pandemic, enacted a 6-month pause at the cost of this on student loans, which not only paused repayment, it canceled interest. Interest stopped being accrued, and that cost taxpayers about $5 billion a month. And after the 6-month expired, it was President Trump's Department of Education that started to extend that pause. And then, of course, when Biden came to power, he extended it more and more. So again, I think you got some blame on both sides of the aisle here.
I would agree, and I was there. So. Let's go to some of the audience questions, and just staying on that theme of how do you fix this? Because it's clear that this is government power that's gone so far beyond what Congress or the Constitution envisioned. And we got a question from the audience. In the future, could Congress draft and pass legislation that prevents a future president? It sounds like we're talking about a fix. I'd love if somebody could share some thoughts on what that could look like. And I'll just add to that, there's this idea that there are other cases happening at the same time, Chevron doctrine, and there's a belief that, okay, finally the court will get the regulatory state under control. True, not true? Does it affect any of this loan cancellation stuff? Can we expect some improvement on the horizon?
Well, speaking for myself, I do expect Chevron to go the way of the dodo bird, but I don't think that would affect really the difficulty in these kind of cases, because as you've said yourself, Michael, and as everyone's kind of agreed, I think almost everyone acknowledges that the merits case here is incredibly strong for the challengers. It's really about the justiciability side of it. Who can sue? When can they sue? How quickly can they get relief? And it's just hard to keep the president from sending money out the door. And so I think that if there were going to be a congressional fix, there'd have to be some sort of creative thinking about, well, how do we make it so that watchdog groups, states, et cetera, can actually put a stop to these things relatively quickly? And that's going to be pretty difficult given kind of current case law around taxpayer standing and so forth. One thing that I have thought about, but I'm not saying anyone should think this is a good idea, is there's a long tradition of these kind of like qui tam statutes and so forth, where essentially you as a private plaintiff could go sue some party on behalf of the federal government. This was all kind of more towards the founding era, to try to get money back if they they defrauded the federal government or something like this. I wonder if you could do a kind of a reverse, like sue to stop the federal government from sending money out the door, and basically somehow give that person a reward that would give them sort of a concrete stake in the dispute. But even assuming that courts would accept that, which I'm not saying they would, that could potentially have blowback as well, because you could imagine a lot of frivolous suits being filed in an attempt to get rewards and so forth. So it's a very tricky area. But to me, that's really the more difficult point, because the difficulty is not so much in, well, oh, the administrative state has too much power. I mean, of course, many people think that it does, but it's even when the court says that, can they say it fast enough, and can they say it in enough cases to keep it from essentially throwing that power around anyway?
And that's the question. And we just got another audience question asking what I think you just answered, which is, could an authority like that grind the government to a halt because there would just be so much of this? I'm wondering, I mean, is there something that Congress can do short of constitutional changes? Is there something that the states can do to give themselves a little bit more leverage over trying to stop some of this runaway spending? Does anybody have a good answer on that?
I'm a little pessimistic on congressional fixes, because you're going to have to convince the president not to veto a congressional restriction on his power. Whichever president's there, they're going to want to have power. And unless you get a veto-proof, majorities in Congress, the president's likely to stop Congress from restraining his power. In the interest of plugging my own, clients, I would think, if the public service loan forgiveness, theory of standing prevails at some level, whether the states or one of my cases or some new case at any level, if it's vindicated, that would mean, maybe it creates its own problems, but theoretically, that would mean a lot of NGOs and local governments and state governments would all have standing to challenge just these kind of student loan cases, not necessarily any sort of disbursement. But when it comes to federal direct loans, they would have pretty broad a range of groups would have standing.
I think I would say one radical fix is probably for the federal government to get out of the student loan business in general, which many people agree with. I think that they wouldn't be able to get the money out the door if that fix happened. But certainly reducing the discretion of the executive in creating these loan programs and setting the terms of income contingent loans. But I would just say, there is a student loan debt problem in this country. People are suffering, and there needs to be congressional action, I think, in order to solve the issue. It just cannot be by the stroke of a pen, and it can't be just a president trying to salvage a campaign promise that he made on the road in 2020.
Another idea just popped in my head is the Anti-Deficiency Act, which prohibits federal employees from essentially, spending money out of bounds. It has penalties, including criminal sanctions, so forth. Now, could that be deployed?
That is a question that comes up, is you have government officials who, at some point they're not just stretching the law, at some point they're breaking the law. And this is maybe towing that line. You could argue that it so far exceeds their congressional authority that I think we all agree they're just trying to get away with something here. And at what point are there consequences, not just for a rejection by the courts of the policies, but consequences for the individuals who are, breaking the law? And the president himself said the Supreme Court tried to stop him and couldn't. So that's certainly an issue in this case, and probably some other policy areas where it really is creating some real constitutional challenges. So just kind of continuing on this line of questioning, I want to make sure we get to as many of the audience questions as possible. We talked about Congress acting in terms of being changing the law, but is there anything Congress could do as a plaintiff?
Well, I certainly think that they could act. I think that they could arguably have standing when the president is basically taking over the appropriations power in distributing funds to people without authorization from Congress. So I think that's a viable legal argument that Congress should look at. I think both houses of Congress being involved in such a lawsuit is always helpful, which is obviously not going to happen right now. But certainly another tool against other loan programs is the Congressional Review Act, which Congress attempted to use against the income, the SAVE plan, but it came up 1 or 2 votes short in the Senate. And it also requires the president to sign the resolution that goes through. However, the next version, the mass student loan cancellation program that's happening now, very likely will be subject to the Congressional Review Act. And so that will be a viable avenue for Congress to follow for that plan.
Sheng, Stephen, Avi, and Paul, thank you so much for being here. I'm wondering if in 30 seconds or less, you could just offer us a bit of a prediction for what happens over the next, let's say, 6 months to a year with some of these challenges and some of the new loan repayment and forgiveness programs that are being proposed. Stephen, you want to go first?
Sure. I mean, obviously these predictions are worth what you pay for them, but I think that we will succeed in getting this rule vacated. I don't know how quickly we'll succeed in doing that. I would hope that we get it in the next few weeks, and if not, we get it from the Eighth Circuit quickly after that. And then I actually think it might stop there. I'm not sure. I'm not even sure that DOJ would want to take it up to the Supreme Court, given that they lost last year, and if they lose here as well in 1 or 2 challenges, I think they might just leave it at that.
Paul?
I would say I would predict the same, and I would also say a nationwide injunction, seems likely, because it would be impossible to implement student loan provisions in some states, but not others. So I think that it would be a total victory, and I hope so.
Avi?
Yeah, I agree with everyone. I think at some point, I don't know when or which level court, this will get struck down. It's just a matter of the particular road that it takes to get there. And the other questions, it was raised a lot during Missouri's arguments about whether provisions are severable or not. So it remains to be seen how courts treat that. And then the other aspect is the scope of the injunction. And I think it has to be nationwide, since that's the standard for APA cases, which this one is. And it would create an impossible patchwork if you tried to limit on a state-by-state level.
And Sheng?
Yeah, I'm not going to disagree with my fellow panelists. I think the writing was on the wall a year ago when the Supreme Court came down with the Nebraska case. But at the same time, I think the president knows he can get a lot done, even if it's illegal, even if he knows a court's going to stop him, he can still, through this program or the next, implement a portion of his loan forgiveness goals, even if a court eventually stops him.
Well, in the face of a very depressingly bad policy, I'm hearing a hint of optimism that just a few months ago I didn't hear. And I remember a similar pattern with the Nebraska case where almost nobody thought there was a chance of stopping this. And yet I hear some optimism. So I think on that note, we're going to leave it there. Thank you all for joining us. We will certainly want to have you back when there are more developments, and hope you'll keep us posted on what's happening with your cases and some of your other work on this topic. Thank you.